Hello everyone, I am an intern at the lawminds and today we will be discussing about the writ jurisdiction and I will be giving you its explanation in a very easy way to understand, also the case law studies to know about each topic. Okay, so let's start. Let's dive into this topic. So first of all, what is the meaning of the writ? Okay, so a writ is a formal order or a decree which is issued by the court to the government or the local authorities or some people, uh, either to stop doing something illegal or commands them to do something. Okay, writs are nothing but it is just to protect the fundamental rights of an individual from getting violated, and also it ensures that the public administrators don't misuse their powers for their personal gain or for any other reasons. Okay, so as we all know, we can also say that the writs are very crucial legal instrument that protects the individual rights. Okay, keep this in mind that writs are very powerful instrument that protects the individual rights. And I've also explained you about what is the writ. Okay, writ is nothing but is just an official order that court issues in order to protect our fundamental rights. Okay, it's specifically for our protection of fundamental rights. This is all about the meaning of writ. It's nothing else but just the protection of our fundamental rights. Okay, our next topic is fundamental rights and constitutional remedies. Okay, so the Constitution of India, it ensures that the fundamental rights of everyone is protected, and where it is mentioned in the part 3 of our Indian Constitution. Article 12 to 35 tells us about our rights. Okay, as you all know about the fundamental rights, like what are they? Like the freedom of speech and the equality and the protection from discrimination and other things. And once it is violated, the court will try to protect it. So it has some are also there which is useful to protect our rights. Okay, so first we will talk about four articles which protects our rights. First is Article 13. So why Article 13 is very important? Because it makes every law void that goes against the fundamental rights. Keep this in mind. Next is our Article 359. It permits the suspension of fundamental rights during an emergency, but with certain exceptions. Okay. Second is third is Article 32. Article 32 gives Supreme Court the power to issue writs. What is a writ? I've already told you. Okay, it gives the Supreme Court the power to issue writs or to stop something illegal or anything that goes against the fundamental rights. It is clearly to protect the citizen of the state. Our fourth one is Article 226. It is also same as Article 32. It's for the Supreme Court, and Article 226 is for the High Court. It gives the High Court the legal power to protect the violation of the fundamental rights. Nothing else. It's the same. Okay. So as you have listened to what I have explained, you can also say that in the jurisdiction, writs are nothing but it forms a backbone of our constitution in order to protect the fundamental rights. Okay, that's it. Our next topic is the part 3 and the Article 32. So the part 3 outlines the fundamental rights that are guaranteed to all its citizens, as you have already know, while the Article 32 gives individuals to what, like to right to approach the Supreme Court in order to protect their personal rights. Okay, so that's why Article 32 is known as the what, like protector and guarantor of our fundamental rights. And also B.R. Ambedkar has also said that Article 32 is the heart and soul of our constitution. Keep this thing in mind. Who has told that Article 32 is the heart and soul of our constitution? B.R. Ambedkar. This question will come in every exams and everything. This will help you a lot, so keep this in mind. Okay. A very leading case that will, like the example of this is the Union of India versus Paul Manicam. Okay, so in this case, the Supreme Court exercised its writ jurisdiction to protect the fundamental rights where arbitrary administrative actions violated personal liberty, reaffirming its role as protector and guarantor of the fundamental rights. So, as I've already told you, why it is known as the protector and guarantor of our fundamental rights, because the Supreme Court issued writ jurisdiction in order to protect his liberty and other things. Okay, once you go through this case now, you will understand why it is called so. Next is Article 226. Let's understand this topic, like the power that's given to the High Court. Okay, like High Court can also issue writs, as you know, but it will issue writs in the state level. And here the state doesn't mean the country. Like in the earlier video, I have mentioned the state, and there the state means the country. But here the state means a particular jurisdiction area. Okay, High Court will always issue writs within its jurisdiction and nothing else. Article 226 and Article 32 are the exact same thing, but just that the Article 32 is for the Supreme Court and Article 226 is for the High Court. And here I have already attached a difference table between the Article 32 and Article 226. This will help you to understand the topic a very easy way and in a very subtle manner. Okay, now we will go to the types of writs and we will understand with a detailed explanation, but in an easy way, also with the leading cases. Okay, the cases that are taken as the examples. First one is the Habeas Corpus. Okay, Habeas Corpus. So what is Habeas Corpus? This writs protect the personal liberty against the illegal detention. Okay, so if a person is detained unlawfully, the court will order or command the authority which have detained him or her to release them. Okay, so for example, the case study which you all need to know is about the Rudal Shah versus the state of Bihar. So what is in this case study? So the Supreme Court held that if a person is illegally detained, not only must be released promptly but also awarded compensation for the period of unlawful detention. So if by any chance the court, the police or the jail, they illegally detained you, so the family members may go to the police station and may issue file a writ in order to release of that person. That's it. That's the only meaning of this Habeas Corpus, nothing else. So in easy words, Habeas Corpus nothing but it's just that you shall have the body. What does it mean? You means the maybe the relatives or other people. You can have the body. Like the police or anyone can't detain someone unlawfully or illegally, but you just, if someone is awarded with a punishment and the family members go to the court and tell them, no, this certain person has not committed this crime, they are detaining that person illegally, you can't detain them. If the family members are saying, the court will not listen to them until and unless it is proved that it is an illegal detention. Okay, we have to prove it, or else you can't exercise this writ. Next is that the Mandamus. What is Mandamus? This writ command a public authority or official to perform a public or statutory duty that they have neglected or refused. Okay, so if a authority is suppose government has advised or told A it has given that A a contract to build a road. Okay, but and B and A contracts with B that it will provide them the raw materials and it will build the road and everything, but the B made a breach of contract, so A is not able to perform that contract. So what it will do, it will go to the Supreme Court and issue a writ that no, this or that, no, sorry, not it will issue it, so it will go to the court, or it will just tell that no, the B made a breach of contract, so I can't perform the particular activity. So the court will command that if you have made the contract, you have to perform it anyway. So for that, you can go through the case study, the Gujarat State Financial Corporation versus the state of Bihar. In this case, the court clarified that Mandamus can compel a public body, keep in mind, a public body, to perform its legal obligation, but it cannot be used to enforce the private contracts. Okay, it's only meant for the public contracts but not the private contracts. Okay, so this judgment establishes that the mandamus has a very vital role or tool to ensure the government accountability. Next is that the certiorari. What is certiorari? Certiorari is this writ quashes order, decisions, or proceeding made without jurisdiction or in violation of the natural justice principles. Okay, so nothing. This means nothing but just to be about informed. Okay, you have to be informed. For this, you can go through the case study of the Golapalli versus APRCTC. So the court issued certiorari to annual actions by public transport authority that were unlawful or violated procedural fairness. Okay, so this rate keeps the administrative actions in check and everything, so you have to see. Okay, next is prohibition. What is prohibition? It is issued to prevent the lower court or authorities to act beyond their jurisdiction. Okay, like see, prohibition and certiorari, these both are like prevention is better than cure. Okay, prohibition is suppose prevention and certiorari is suppose cure. Okay, so what is better? Like to forbid, if the court has made some decisions, the lower court, and it is supposed to deliver a judgment but it is not right, so it prevents from delivering that judgment. So that's a writ that will be issued by the Supreme Court or the High Court to forbid. So it is better, right, than the certiorari, where it has to be like informed about that thing after it has happened. So it is not good. So we have to first go through the prohibition. Got it? Nothing but this writ just differs from certiorari in timing. Prohibition acts before the act is done, and certiorari after the act is done. Okay, like it is like to forbid, and that is to be informed. That's it. Next is that the quo warranto. Quo warranto was that the by what authority? Like if a person holds a public office or position and challenges the unauthorized occupancy, the court has the power to issue a writ and just ask by what authority. It only ensures only rightful persons hold public offices. Okay, that's it. That's the 5 writs. Habeas corpus, you should have the body. Mandamus, we command. Prohibition, to forbid. Certiorari, to be informed. Quo warranto, by what authority. Okay, that's it. Next are the conditions and the limitations of the writ jurisdiction. Okay, so the court exercised discretion in issuing writs. Writs are like issued primarily against the public authorities, not the private individuals. Okay, keep that in mind when performing public functions. They are not generally issued if other effective legal remedies already exist. Before issuing a writ, we need to see if there is other legal remedies present so that we can exercise them. If no other is available, we can directly go and issue a writ, as it is the last option. Okay, so this was all. As I have told you, what is a writ, which important article you need to remember, what are the 5 type of writs, the case law and everything. I have also attached the screenshot and the videos. You can go through them. Screenshot and the pictures. That's it for this video. Thank you for listening. I am an intern at the Lawminds, and if you have any doubt, feel free to ask. Thank you so much.